Sam has been working as a staff writer at Ballotpedia since 2019. He studied political science and literature at Ashland University, has an MA in political theory from the University of Dallas, and is currently working on his PhD dissertation. Sam is also an editor for Ramify, the journal of the Braniff Graduate School, and has written chapters for several academic textbooks. So I'm really looking forward to hearing his lecture today, and I will go ahead and turn it over to Sam.
Thanks so much for that introduction, Sarah, and thank all of you guys for joining us today. This is a particular joy to me because I'm used to lecturing to either academics who want to argue with me or students who are forced to be in the room in order to make a grade. So I appreciate you all being here. As Sarah said, I work for Ballotpedia. I work on the State Supreme Court's project, and I'm going to be talking to you guys about selection methods and how they vary throughout the different states. So if you're interested in this kind of thing, this coming fall, we're basically revamping all of our State Supreme Court pages and the different justice pages. We're going to be providing more information on the way that selection is done in particular instances and particular years, and also more information on governing majorities on the courts and particular rulings. So if you're interested in that, stick around, hang around until the fall of this year, and you'll get to read a lot more about this. So let's get into this. So the first question, I guess, if you're going to consider what kind of selection method you want to use to select judges, is you have to figure out how you want a judge to act, right? Elections, appointment, all these different structures. They're basically incentive systems, right? So you want to pull the right strings to get justices to do the things that you want them to do and to act the way that you want them to act. So I put a slide together on the current code of conduct for United States judges. And I'll go ahead and read the canons to you. So Canon 1, a judge should uphold the integrity and independence of the judiciary. Canon 2, a judge should avoid impropriety and the appearance of impropriety in all activities. Canon 3, a judge should perform the duties of the office fairly, impartially, and diligently. Canon 4, a judge may engage in extrajudicial activities that are consistent with the obligations of judicial office. And Canon 5, a judge should refrain from political activity. So these canons in the character of judges have to do essentially with maintaining integrity and maintaining independence, keeping judges free from making decisions predicated upon their political dispositions or what political party they might be a member of. This is pretty consistent throughout our nation's history. From the time of the founding until now, this same kind of language has been used to pinpoint what kind of judges we want on courts. Integrity, free from politics, independence, judging the case at hand. That's how judges basically see their job. So what is judicial selection in the states like today? There's basically been three revolutions or three really important eras. And there's also three types of appointment that you'll see throughout the states. Today, we have a hodgepodge of judicial selection methods used across the states, mostly because there have been these three waves of innovation in our selection methods. So scholars generally break it down into these three eras, and at Ballotpedia, we consider these three broad types. Within these three categories, there are constituent types. For example, election can be broken down into partisan elections, nonpartisan elections, and there's even a hybrid method of election, as you see in Ohio and Michigan, where there's a partisan primary followed by a nonpartisan election. So the first stage was the American founding. They endorsed, or they used across the board, the only type of selection method they used was direct appointment of judges. This was either direct appointment by the governor, or this was direct appointment by the legislature. And largely, you see this being adopted from 1776 to 1790, when the original colonies were writing their constitutions. So after that, we have the Jacksonian era. And largely, sorry, my dog is upset that someone is coming to the door. He also is tired of quarantine. So after that, we have the Jacksonian era. And largely, the system that they used to select justices during this time was election. They shifted away from direct appointment by the legislature and by the governor, and started using election. This was from 1840 to 1860. And then the third era is the administrative era. And this is largely the era that still kind of governs us. The majority of our states use the assisted appointment method, which will be the last one that I'll talk about today. And this was adopted from 1940 to 1980. So we'll talk about each one of these different kinds of appointment, and I'll go into the details. So we'll start at the beginning, the American founding. So Publius writes in Federalist 51, if men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. So the courts, according to Publius and according to many of the founders, played this very special role of obliging the government to control itself, right? Laws are passed by the legislature to control men, to advise their actions, to make sure that they're not doing anything that harms the rights of others. And the courts would make sure that the laws passed by the legislature weren't tyrannical. They weren't harming men. They weren't unjust laws. So what you see courts do is laws are passed by the legislature. They go up the court system. They come to the state Supreme Court or even the federal Supreme Court. And the court has to decide whether this law is unconstitutional or unjust or overbearing. So the courts play this really special role. And the founders took the courts very seriously. And they wanted to bolster its powers in order to enable it to do this. Publius also says in Federalist 47, the accumulation of all powers, legislative, executive, and judiciary in the same hands, whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. So this is something that you've probably heard a lot about when you've read about the American founding. They believed in the separation of powers, right? They thought that it was tyrannical to allow the executive to have power over the legislature, like the king at the time had power over the House of Commons, and to allow the executive or the king to have power over the judiciary by appointing them. So this raises an interesting question, right? Does direct appointment of our federal judges, which we still use today, and direct appointment of our state Supreme Court justices, does it violate this principle? Is this the very definition of tyranny that the founders adopted? Well, we see in the Declaration, they talk about this. They write, the king has made judges dependent on his will alone for the tenure of their offices and the amount of payment of their salaries. Let's compare their criticism of the king to what they then adopted in the state constitutions. Massachusetts, their constitution written in 1780. This is Chapter 2, Section 1, Article 9. It reads, all judicial officers, the Attorney General, the Solicitor General, all sheriffs, coroners, and registers of probate shall be nominated and appointed by the governor, by and with the advice and consent of the council, his council appointed by him. And every such nomination shall be made by the governor and made at least 7 days prior to such appointment, right? So the Massachusetts Constitution that they passed right after they'd written the Declaration of Independence vests the governor of the state with the power to appoint the judges. The question is, how different is this from what they had just criticized the king for doing? Well, it's different because in some sense, one can argue that it's different because it follows the principle of federalism. It's not that the king of the nation or the president, it's not that Washington told Massachusetts that they had to use this selection method. And of course, right, it's more localized. The states were much smaller, so they thought that this might work out. But the question is, right, why follow this same principle into the federal government? So were other states different? North Carolina, their constitution written in 1776. This is Section 13. It reads that the General Assembly shall, by joint ballot of both houses, appoint judges of the Supreme Courts of law and equity and hold their offices during good behavior. So this is direct legislative appointment as opposed to Massachusetts, which embraced direct gubernatorial appointment. Then we have Virginia, right? This is kind of the seat of the American founding, right? We have all these presidents who were from Virginia. So did Virginia do anything any different? Their constitution reads, written in 1776, The Court of Appeals shall consist of not less than 7 nor more than 11 members to be appointed by the House of Representatives. They shall hold their offices during good behavior, for breach of which they shall be removable by an act of the legislature only. So the wording of this right is very similar to the critique of the king in the Declaration of Independence, right? Not only does the legislature appoint, but also the legislature can choose to remove the state Supreme Court justices. Now, think of this scenario, right? You have judges put on the Supreme Court by the legislature. They are in some sense dependent on, indebted to the legislature for their very office, their salaries, as the Declaration says. What if the Virginia legislature passes a law that is blatantly unconstitutional according to the people, and it goes before that court? If you're a justice, you might be thinking about the power that the legislature has to remove you. You might also be thinking about, well, that's my friend, right? He scratched my back by appointing me to this court. Maybe I shouldn't declare unconstitutional his policy that he sponsored in the General Assembly. Of course, right? If you declare that someone's policy that they've endorsed is unconstitutional, this is a very large attack on a member of the assembly at the time of the founding, right? The Constitution was taken very seriously. And if you were considered as someone who was trying to actively violate the Constitution, you're likely not going to get reelected. Reelection wasn't as it is today, where there's an 80% reelection rate. Reelection was very tough to come by at this time, especially if someone thought that you were passing unconstitutional laws. So I just wanted to boil this down to, after this very, very dirty, rough, simplistic discussion of the constitutions of the states at this time and their state Supreme Court selection methods, I wanted to break it down into some pros and cons that you can use as takeaways. So some pros: federalism, right? The states were left to themselves to decide selection without federal interference. It's not that the king thrust, or it's not that Washington or the president at the time, or James Madison, who wrote the Constitution, thrust these selection methods upon the states. They chose them themselves at conventions to draft state constitutions, and the people accepted them. Of course, a con associated with this, it seems to contradict the ethos of the Declaration and the rebuke of King George for controlling judges. Another pro: independence. The judges can interpret the law independent of popular passions, right? There's no election. So the judge doesn't have to consider, when he's making his decision, when he's writing his opinion, he doesn't have to consider whether the people will like this or not, as much as he would, at least not as much as he would if he were to face election. This can be a pro and a con, I suppose, but this is something that the founders took very seriously. They wanted the judges to sit. Hamilton called them mere judgment. They were not the sword or the purse of society, but they were to exercise mere judgment, and therefore they were the least dangerous branch. And they could only be mere judgment if they were independent of popular passions. The con associated with this, of course, there's potential to create judicial dependence upon another branch of government rather than upon the people. So another pro: effectiveness. Judges can focus on their duties within the courtroom rather than focusing on campaigns. Keep that in mind when we move on to election after this slide. A con of this is these constitutions were adopted somewhat hastily. They were to govern the states during the Revolutionary War and directly afterwards, right? They were probably more interested in winning a war than figuring out the best way to make judges accountable and unbiased. Especially because, right, Hamilton and a lot of the founders saw the judiciary as the least dangerous branch. So what about elections? The Declaration of Independence, you've heard it before. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted through consent, by the consent of men. But they didn't follow this through, right? They didn't follow this consent principle through in the case of state Supreme Court justices. 0 of the states adopted elections as their method for selecting state Supreme Court justices. Instead, every single state at the time of the founding chose to embrace some form of direct appointment, whether that be legislative or gubernatorial appointment. However, by the 1840s, the people started to see appointment of state Supreme Court justices as a threat to impartiality. State legislatures had begun to spend on public works, leading to public debt, and their spending went unchecked by the state courts. Many argued that this kind of spending was an unconstitutional act and abuse of power, and they thought that the courts were not checking the legislature or the governor because they were indebted to them to appointment to the bench and could be removed by them. So we see sweeping changes between 1846 and 1860. Of 21 constitutional conventions held during these years, 19 approved constitutions that allowed the people to elect their judges. Before the Civil War, 21 of the 30 states had adopted popular election, and 23 of the 30 states had popular election for at least one court in the state. Very big changes. So how did this begin? So Mississippi was the first state to adopt elections for judges in a constitutional convention in 1832. The state constitution that they amended was only 15 years old. It was written in 1817. Then New York, the second state to adopt elections as the mode of selecting state Supreme Court justices, did it in 1846. This is a whole 14 years after Mississippi had adopted election for their judges, and no one else had done it for 14 years. People were very skeptical of this shift. So from 1846 to 1853, a landslide of 20 states adopted the election method for judicial selection. So let's take a closer look at Mississippi to figure out how this worked, why this shift took place. The history behind this is really interesting. So in 1832, Mississippi called a convention, right? The background of this was that Mississippi was getting larger. It was filling out. You had the Choctaw Purchase, you had land expanding, and you had groups populating this new land. The federal government was giving money so that people would move to these lands and they would settle them and they would start to create farms. This really shook up the dynamic of the state itself, right? In the Deep South, you have people, rich farmers, who are in agriculture, who are settled. They're not the people who are moving to these districts and populating them with federal money. They stay put and they farm the land that's been in their family for a long time. So you have people migrating south and west and populating these lands. And there's little communities starting to sprout up of people who are not the rich aristocrats in the South. So the dynamic of the state is really getting shaken up at this point in time. Thus, the people of the state called for a constitutional convention. And there were sweeping changes made because of the new people moving to the state and populating this land. For example, and by the way, these were all very, very popular changes. They were very democratic changes to empower those poorer citizens who were moving to Mississippi. So an example of some of the resolutions passed, they amended 2 sections in their declarations and their Declaration of Right in the state constitution. If you know anything about declarations of right in constitutions, in state constitutions, they were very difficult to change, right? They were settled. Think if someone today came out in the legislature and they wanted to change our Declaration of Independence. They wanted to take the right of liberty or the right to pursue happiness out of the Declaration of Independence. It wouldn't be very popular. Nonetheless, these 2 sections were added to Mississippi's Declaration of Rights. The first one was property qualifications for voting are to be never required. So no more property qualifications for voting. Everyone can vote. Another one added to their Declaration of Rights was the tenure of all offices would be for limited terms. So they limited the terms of representatives, of their Supreme Court justices, of their governors. So those are 2 very democratic resolutions that were passed to amend their Declaration of Rights. And they followed these through into the body of the Constitution. In the body of the Constitution, they wrote that office holding requirements for the legislature are to be struck, right? So prior to this, you had to either serve in the militia or you had to have some degree of property. There were property qualifications to hold office. They struck both of those. Anyone could be elected as long as they won election. They also added to the Constitution a periodic census and reapportionment for the legislative branch, and all limitations on the size of the House of Representatives was removed. So over time, these populations that are booming are growing. The communities that are sprouting up because of federal land grants, they're getting bigger. And if you're taking censuses, right, they're going to get more representation in the House. It's going to become a much more democratic state. So the judicial article, despite everything that I just said, the judicial article was the most amended section of the Constitution. John Quitman headed the Judiciary Committee. He's a very interesting fellow. He's the most famous person to come out of this convention. He's later elected governor of the state of Mississippi, and he becomes a federal representative. Very interesting guy. He's a protege of John Calhoun. And Stephen Duncan, in a letter, he was a member of the 1832 convention. In a letter, he described three groups. He described first the aristocrats. The aristocrats were the ones who argued for gubernatorial selection with Senate consent. Before this, it was just direct gubernatorial appointment, no Senate consent. They wanted a very moderate and mild change. The second group, they were the sort of halfway point in between the two really extreme groups, were called the half-hogs. They argued for election of lower courts, but appointment of the state Supreme Court, appointment by the governor with Senate consent. They also wanted some more moderate changes. And the third group were the whole hogs, who wanted election of all judges in the state. The whole hogs were the most well represented at the Constitutional Convention. There were 5 committees at the convention. John Quitman headed the Judiciary Committee. He opposed state Supreme Court election. He was probably a half hog, not quite an aristocrat, but he was one of the more conservative or aristocratic half hogs. He wasn't opposed to election of some courts. And by the way, Duncan's terminology, the names for these people, they were embraced by newspapers all throughout the states. All these states started writing about hogs in their papers when referring to their delegates to the state constitutional convention. Very interesting. So John Quitman, as I said, headed the Judiciary Committee, the committee that made the most sweeping changes to the Constitution. He opposed state Supreme Court election and criticized the Constitution as one of the greatest outrages ever committed on a free people when the Constitution was not submitted to the people for approval. So, right, the federal convention submits the federal Constitution when it was written to the people so that they can approve it. This was common practice. Delegates weren't supposed to just write constitutions and thrust it upon the state, make it the law. The people had to approve it. Mississippi didn't do this, despite all of the democratic principles put into their constitution. Nonetheless, right, it stood, and Mississippi started electing their state Supreme Court justices. And it was a very interesting thing that you saw. Everyone argued throughout the United States this was a big debacle. Everyone argued that they would just start electing anyone. There would be no judicial qualifications taken into consideration. You would get people with no experience on the bench or even in the courtroom, and they would just be purely political. And they would do things for political purposes. But on the contrary, you see basically the same sorts of qualifications of the people who were elected, of the judges who were elected. This leads Quitman in 1845, when he's in the federal legislature. He has a comment where he basically endorses state Supreme Court election. He says that he was wrong. This is probably the best method of selection. So after this, right, we see a bunch of states start adopting this, as I've sort of laid out. So that's a positive example of state Supreme Court elections. Now let's move to a more negative example, a counter example. How does this actually work today? Very differently. So an example is that Sherry Beasley, who is a justice on the North Carolina Supreme Court, has stated that she writes all of her opinions at night. She has to, because she's busy campaigning during the day. She has to stay, the exact time stated in the Politico piece that she did an interview for, it's 2 a.m. She campaigns during the day, can't focus on her job during the day because she has to make sure that she's reelected. She writes her opinions at night. In 2004, 2 Illinois judges raised $9.3 million. This was more than 18 out of 34 US Senate races that year. Attorneys wrote $100,000 checks to the state Democratic Party, and the state Democratic Party spent those on the campaigns, even though it's a nonpartisan election state. Lloyd Carmeier, one of the judges running for election in that race, stated, "That's obscene for a judicial race. How can people have faith in the system?" Of course, he's referring to the fact that these candidates, who are supposed to be unbiased and according to the Judicial Code of Conduct are supposed to be above politics and not participate in politics, they're entirely reliant on the money that that partisan entities give them for their campaigns in order to win, in order to get a seat on the bench. So Carmeier is pointing to what a lot of people have started saying, is that people can't have faith in judges if they're just judging for the sake of politics. They're supposed to be above politics. So campaign finance varies state by state, but more than 85% of state Supreme Court judges must stand for election at some point. This, of course, takes into consideration something that is a product of the assisted appointment method, which is retention election, which we'll get into in the next set of selection methods. So some pros and cons of Supreme Court elections. Pros, it's very transparent, right? The people become informed. They get excited about these elections. If you look at the Wisconsin election, you had people very excited about the election between Jill Karofsky and the incumbent. Garners more attention from the people. The people become excited about the courts. The con associated with this, of course, is that the constant campaign cycle has the potential to detract from essential duties of the office. This is what we saw with Sherry Beasley, right? If you're too busy campaigning and worrying about politics, you can't focus on your job as much. Or at least you have to be very special and dedicated to stay up until 2 a.m. to write your opinions. Another pro, accountability. It bolsters the separation of powers because justices are beholden to the people as opposed to office holders in the state. The con associated with this, of course, because judges are dependent upon the people, politics begins to penetrate into judicial decision-making. Instead of merely interpreting the law, justices have to concern themselves with public image and the popularity of written opinions. Not only that, but they have to consider whether or not parties and political entities are going to fund their campaigns, right? They need money to win campaigns. So as you can probably start to see this fleshing out, judges have to be dependent on somebody, which is what makes this issue so hard. The question is, what is safest? Making the judges dependent upon politicians, upon the governor, upon the legislature, or making judges dependent upon parties and the people? So moving on to assisted appointment, you've probably heard this referred to as merit selection, or the Missouri Plan. It's called the Missouri Plan because Missouri was the first to adopt it. It's called merit selection because a lot of the reformers during this time, they drew off of merit selection of the civil service. They used that rough kind of idea of merit selection for selecting the civil service, and they adapted it to the courts, made sure that the courts were reliant on someone other than the people or politicians. The Missouri court's website describes this change in the following language. They write, and this will be very interesting to you if you thought that the elections were an interesting or posed interesting problems. The court's website nonetheless writes, during the 1930s, the public became increasingly dissatisfied with the increasing role of politics in judicial selection and judicial decision-making. Judges were plagued by outside influences due to the political aspects of the election process, and dockets were congested due to time judges spent campaigning. Then, in 1940, voters amended the Missouri Constitution by adopting the nonpartisan selection of judges court plan, which was placed on the ballot by initiative petition. The adoption of the plan by initiative referendum resulted from a public backlash against the widespread abuses of the judicial system by the boss Tom Pendergast political machine in Kansas City and by the political control exhibited by ward bosses in St. Louis. The Missouri Nonpartisan Court Plan, commonly called the Missouri Plan, since has served as a national model for the selection of judges and has been adopted in more than 30 other states. So the Missouri court's website directly calls into question partisan election and even nonpartisan election of state Supreme Court justices, right? And states where there are very big cities where control is basically concentrated, in the middle of the 20th century and early in the 20th century. And if you want to hear somebody talk about this in a really interesting way, read some of Teddy Roosevelt's speeches on this. They believed that in states where politics was concentrated into one major large city, and this commonly happened, that there were bosses of political machines who would basically get a bunch of people around them, because they had a bunch of money, and they would be able to basically lobby and get the people elected who they wanted to be elected. This was a particular problem in Kansas City. So I've described why the change took place, but the question is, what is assisted appointment? It's the most complicated of all of them, right? We know what appointment is, and we know what election is. We're most familiar with those. So it basically, I break this down when I think about assisted appointment into 4 phases. Some might say 3, but I say 4 because important things happen in each phase, right? So it's the method of selecting state Supreme Court judges that first begins with the Judicial Nominating Commission, selection of people to put on that commission. Second, those people on the Judicial Nominating Commission select a short list of judges. It varies from state to state. Alaska's state constitution is an interesting example of this because their constitution only says at least 2. So technically, according to the state laws, the Alaska Judicial Nominating Commission could select 2, or it could select as many as they wanted, 50, 60 judges from the governor to choose from. Third, the governor must make a selection from the short list in most states. Some states actually allow the governor to basically ignore what the Judicial Nominating Commission says. That very few states allow him to just do this. And then other states allow the governor to basically get one reroll, say, I don't like anybody on this short list, give me some more judges. And then 4, those justices stand for a retention election after serving for a set number of years. Of course, that set number of years varies. This retention election is where they're put back on the ballot and they basically have to run. And the people decide whether or not they've been a good judge or a bad judge. The election that I referred to a little bit earlier, Kurofsky and Kelly, this is what just happened with Daniel Kelly in Wisconsin. He was the incumbent. He wasn't appointed through assisted appointment. He was appointed because of a vacancy. And he went up for election against Joe Kurofsky, and Joe Kurofsky beat him when he stood for retention election. So across the states, qualification for membership to judicial nominating commissions varies. However, the majority of judicial nominating commissions contain 3 governor-appointed members, 3 members appointed by the state bar, and the Chief Justice serves as the chair. Some states, like Massachusetts, allow the governor to select every member on the Judicial Nominating Commission. And some states, like New Mexico, even have university professors on the Judicial Nominating Commission. The dean of the New Mexico Law School is on the Judicial Nominating Commission for New Mexico. So what do judicial nominating commissions do? The primary job of the Judicial Nominating Commission is to provide a list of judges from which the governor must choose. It's the primary job. This is basically, I've already talked about this. This ensures that the governor of the state doesn't have complete power over the justices on the state Supreme Court. We talked about this when we were talking about the founding method, right? Direct appointment. Some state laws, as in Alaska, charge the judicial nominating commissions with publishing reports on judge performance for retention elections, right? They publish these reports and they're actually circulated to voters, and the voters read these. The state endorses them by law, vis-a-vis the Constitution, and the people read these and they make their votes according to the evaluation that the people on the commission give the judges. So I could go on and on about assisted appointment. It's very interesting and nuanced, and a bunch of different states have very, very different modes of organizing assisted appointment. But I just wanted to give you guys a brief explanation of it and then some pros and cons. So pros, there is separation of powers. Judicial nominating commissions can take sole power of appointment away from the governor. The con associated with this is that sometimes that power doesn't trickle down to the people. Some states don't publish the applications of judges when they apply to the state Supreme Court, so it limits transparency, right? This is a particular problem that I've had during my research. some states, it's illegal for the Judicial Nominating Commission to publish the applications of these judges, which are very informative. Shows many of them are very detailed. They show basically all the work that the judge has done from the time that he was working in private practice as an attorney to the time that he applies. So they give you a ton of information on the judge. Another pro, accountability. Reports from the Judicial Nominating Commission can create transparency and hold judges accountable. A con associated with this is that the citizens in the state don't play a role in selecting the members of the Judicial Nominating Commission. So one might ask, how or why should the people have faith in the reports given from the Judicial Nominating Commission if the people themselves aren't the ones who select the people who are on the commission? How can they trust them? Another pro, and this is only in some states, but I do think that it's very good. Diversity. Many states require representation from all parts of the state on commissions. They're divided into districts, and there has to be at least one member from every single district. Some states even go further, and they have a partisanship requirement. At least half the members have to be from conflicting political parties. One party can't control more than half of the commission. You see this play out in really interesting ways. Arizona actually gets around this pretty well because they have a bunch of independents in name on the commission, but really those independents, they basically agree with the Republican governor. So some states have a way of getting around this. And then of course a con associated with this, in some states the governor appoints a majority or even all of the members of the commission. The question is, right, how is that any different from the governor just getting the consent of his own council? The Judicial Nominating Commission is kind of just his council that only deals with judicial selection in such states. So what does it look like today? I said we have a hodgepodge of judicial selection methods. This is the graphic that's found on our site right now. Today, assisted appointment is the most frequently used. 22 states use assisted appointment. Elections are the second most commonly used. 21 states use elections. 13 states hold nonpartisan elections, 6 states use partisan elections, and 2 states use a hybrid method. Direct appointment is the least used mode of selection. Only 7 states use it. 5 states use direct gubernatorial appointment, and 2 states used direct legislative appointment. So the question that I want to leave you with is, imagine yourself at a constitutional convention like the folks in Mississippi. Today, we have a variety of states that have embraced different modes of selecting state Supreme Court justices. Do you think this is a good thing? Should we have one mode of selecting state Supreme Court justices across the country? Or should we embrace the variety of selection methods across the states? If you were writing a new constitution for a new country, which selection method would you choose? Thank you so much for your time, guys. I will take any questions that you guys have. Okay, so I have a thank you. It's my pleasure. I love talking about this stuff. If anybody has any questions, you can go ahead and drop them in the chat, or you can say them verbally if you'd like. No questions? Is there one that stuck out to any of you? One mode of selection? Connecticut, I believe they have, let's see. I haven't done as much research on Connecticut. I believe Connecticut has assisted appointment.
Okay, well, if there aren't any other questions today, I guess we can go ahead and wrap up. Thanks so much for joining, everybody. And thanks
Hi, can I ask a question?
Oh, go ahead. Sorry.
Oh yeah, I had to call in, so I had to actually look up how to unmute myself. But yeah, I actually have two questions. I was the election method that you described, and how like one of the cons was they're kind of like always in this pattern of like running for election again. It it occurred to me that a compromise for something like that would just be to make the terms longer, like make them like 10-year terms or something like that, as opposed to a 4-year term. Are any states doing that? Is that, or in your opinion, is that a potential compromise to make an election method where they wouldn't constantly be running for re-election?
Yeah, that's a really good question. And in fact, we see some states who have even longer terms. And it is true that that I think these states do become less political. I think you're actually right about that. But is there my question, and the question that someone who endorses, I think, partisan elections would say, is there what about the law of diminishing returns, right? How long? What's the sweet spot for term lengths for these people? I think that's what someone might say. How do you hit that sweet spot? How long can we make terms without basically having judges entirely free of the judgment of the people? And of course, I think from my research on this, actually, people actually, on the whole, I think, like the election method more. They like to have some say in who their judges are going to be. However, the opponents of the election method for state Supreme Court judges are very, very fierce opponents. The Brennan Center does really good work on putting the statistics out on these elections. But yeah, I actually think that your solution is probably a good one. That just making the terms longer would probably be the most helpful way of limiting partisanship on courts.
Thank you. Can I ask you one more question?
Yeah, sure. Go ahead.
So your parting question was for us to think about, which of these methods seems like the best one, and I'm curious, how would one, or what's your opinion on how one would judge, like looking at how well each system has functioned? Like, is there a metric that one can use to look at the results of judgments over time to say, oh, this state was more balanced in their judgments, or like, does that question make sense?
Yeah, absolutely. It's the question that I've been thinking about for the last 3 months, because no such system exists. So that's what we're trying to do at Ballotpedia and the State Supreme Court's project, and we're hoping to have something like that on the site in the fall. So the unsatisfying answer to that is that the information on this is very diffused, and it's really difficult to sift through. Some of these judges have been on the court since the early 80s, and yeah, it's very different how you go about getting information on this stuff, depending upon what the state is like. I called the Wyoming courts the other day and talked to their clerk of court, and they wouldn't give me hardly any information. And of course, Wyoming is one of those states that they're not the most technologically advanced. They do their things in a very localized way, and you just know everybody in the towns, right? So you don't need to, you don't have big press going on there. So it's really hard to get this kind of information, and that's kind of what we're trying to figure out. Sorry.
Great, thank you very much.
Answer. Yeah, thank you for your question.
But still informative and helpful. Thank you.
Yeah. So we have a question from Emily Herndon. How does Illinois select its judges? Illinois uses the election method. It's very interesting because technically they're a nonpartisan election state, but you have justices like Justice Burke. And there are laws in Illinois where you're not allowed to contribute to Mrs. Justice Burke. There are 2 Burkes on the court now, actually, unrelated, surprisingly. But Mrs. Justice Burke, she actually participated in an election, raised for Toni Preckwinkle. Well, her husband did, who was also involved in politics. And there was a big fiasco on this. Ballotpedia did a big story on this. Illinois has laws where you're not allowed to be involved in politics in a monetary way when you're on the courts, partisan politics, that is. It's a nonpartisan election state, but you have people who are actually involved in partisanship. Very interesting state. How does one get involved in this process? That's a good question, Donna. I think the way that one gets involved in this process is Tocqueville, Alexis de Tocqueville, one of my favorite authors, he praises the ability of the US courts. And he basically says that if there's one thing that's going to save America, it's the court system, because it gets individuals, it gets democratic people involved in the rule of law. And knowing the rule of law is very important to Tocqueville, especially if you're a democratic person who likes elections and those kind of things. The best way is to talk to the courts, right? Participate in elections if your state has elections. Serve on juries. Read about it. Write to the state courts office, the state clerk of courts. You can just call them. You don't have to be someone like me who works in doing political research in order to talk to them. Oh, that's good. Yeah. I think any way to get involved in politics is incredibly good, just to stay informed. Are there any other questions? If not, I really appreciate you guys being involved and asking some questions. I'm really happy that I got to share some of this with you.
Yeah, thank you so much to everyone who attended today. If you do think of any questions after this call, you can always reach us at editor@ballotpedia.org. So I just want to say thanks again to Sam Postell for leading this session. And that'll conclude our Ballotpedia class lecture series. Thanks so much, everyone.